Hey everyone, it's Rob Ryder. On January 7th, 2016. And I had an aha moment last night, so I had to stop and do a video. Although I don't have it all together in my head yet, but it was, I figured it was worthy of distributing, so this is where we are. Mainly we're going to talk about legal descriptions. And, that would be, well, what is the legal description of the property that you own? And make sure that that's correct. And if they're trying to say, well, we're going to foreclose on this other property that has a close but not the same legal description, you can say, well, that's not my property. Go ahead and do as you please, but leave my property alone. And we're going to find out that they're not using proper legal descriptions. And uncanceled revenue stamps. Now, these revenue stamps are used in the transfer of property, and they put them on the warranty deed, or what else would it might be called, a grant deed, I guess, or whatever the name is. But it's a thing that we think of as being the deed, which really isn't the deed to the property. They never give you the deed. They call it a warranty deed. It's like an agreement. To me, it's like a receipt. We used to try to acknowledge the warranty deed, but that isn't the right deed. But on the warranty deed, they do put revenue stamps, and they're not canceling them properly, which shows that the recordation has never been done. They've been filed for record, but not recorded. And then there's these affidavits for the assessor. Right? So the assessor, like here in Michigan, every township has an assessor. And when you look at the way they're set up, they're not elected here. They're appointed. They could be elected, but they're appointed. And everything that they deal with is forms from the Department of Treasury. So they're not really working for the local township. They're working for the state treasurer, which makes them, the state officer within your local jurisdiction. And, that could be very beneficial. Anyways, there's affidavits that are supposed to go to the assessor as part of this transfer of property, and we're not doing it. At least it doesn't appear. The couple of people I talked to said we never did that, so you're going to find out for yourself by looking after we take a look at a few. And then the name of your city, municipal corporation. I think of the county seat as the city of Grand Rapids, but that's really not the name of the municipal corporation. And not that it has anything to do with the legal description or revenue or whatever, but it would if you were trying to bring a suit against the city. You've got to sue them in their proper name. Right? They can't sue the city. The city didn't do it. The municipal corporation that runs the city is responsible. And as I said, I am Rob Ryder. Well, that's my avatar name for doing this kind of stuff. Court of Record, AOL.com is my email address. My phone number if you need to call me. But, I don't want to talk about land patents and all this other stuff, right? I'm just going to point things out now and deeper later. This is just kind of pointing out things that the law says that you should point at and say, hey, this law says this and you're not doing it. You're breaking the law. Quit trying to steal my property. Something like that. So who is an assessor? One appointed to assess the person or property. Assesses the person. I wonder if that would satisfy the Sesta-KV Act of 1666, where you need to appear before the proper magistrate and put a claim in for your property. That's what I'm going to try to do. An inferior officer of justice who sits to assist the judge, and one who sits by another as next in dignity. So assessors in ecclesiastical law are learned persons whose function is to counsel a judge with whom they are associated in trial of causes. They are called assessors because they sit beside the judge. Assessors are required to examine documents, consult precedents, in general explore the laws for points bearing on the cause of issue. So basically, I'm not going to read this whole thing, right? An assessor has more to do with ecclesiastic law than somebody who's going to figure out what your property is worth. That's what their specialty is. So now the question is, well, whose property is it? Well, that would be their specialty too, to put a value on it and determine who the owner is. So let's look at a few things really quick that so I can get these out of the way, because I got so many little pieces of paper floating around I can't keep track of them anymore. So where Phoenix? Right now we're going to look at this thing about the name of the municipal corporation, right? And then you can decide. So in 1850, Phoenix, I think this is 1850, an act to incorporate the city of Phoenix, be it enacted by the Legislative Assembly of the Territory of Phoenix, so territory times, where it said that the district of county embracing the north one-half of Section 8, Township 1 North, Range 3 East of Gila and Salt River Meridian, Maricopa County, Arizona Territory, heretofore known as the town site of Phoenix, in the county of Maricopa, shall be city by the name of Phoenix, and the inhabitants residing therein shall be a corporation under the name and style of, this is the name of the corporation, the Common Council of the City of Phoenix. And by that name they and their successors shall be known in law, and shall have perpetual succession, may sue and be sued, plead and be pleaded, complain and defend in all courts and all actions of proceedings, and may have a common seal, and change the same at pleasure. May purchase, hold, convey real or personal property for the benefit of the said city. And so that's who's holding all the titles to your property. If you're in a city, if you're in an unincorporated part of the county, it may be that's being held by the county seat city. Don't really know yet. Could be that it's being held by the township, who should have it. I mean, that's who mine should be. But when you go and check these people's oaths and bonds and so forth, and you find they don't have them, well, you just have to say, well, that really isn't the government, right? That judge sitting there isn't a judge because he doesn't have a certificate of election. That mayor's not a mayor because he doesn't have an official bond. He doesn't have the proper oath, and he doesn't have a certificate of election, and goes on and on and on. But you can see here that the name of the city, so if you wanted to sue Phoenix, you would have to sue the Common Council of the City of Phoenix. That's the name of the corporation. And the inhabitants residing therein shall be a corporation under the name and style of the Common Council of the City of Phoenix. So what they're doing is they don't want you to become an inhabitant. And so they're never transferring the property to you that's within the boundaries of the city, so that you could say, well, I'm an inhabitant. I live right here. Right? They don't want you to be an inhabitant. They want you to be a settler. And you can go look at the two definitions, and one is somebody who lives in the city and gets their rights from the city. And a settler is one who is an area where there's very few inhabitants. Well, we've been overtaken by settlers, and we're not being allowed to become an inhabitant. So, Grand Rapids had the same thing. Blah, 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 shall be, and the same is hereby declared to be a city, and by the name and style of the city of Grand Rapids. So the name of the city is Grand Rapids. And all the freemen of said city, from time to time being inhabitants thereof, shall be and continue to be a body corporate, body politic, by the name of mayor, recorder, alderman, and freemen of the city of Grand Rapids. And by that name, they and their successors shall be known in law, and shall be and hereby made capable of suing and being sued, pleading and pleaded. I'm not going to read the rest. You can just stop and read it. It's the same stuff again, right? And now they got this thing about the word freeman, and you should go look it up, and you will find that even today in the city of London, they have a ceremony where people who have been chosen to be freemen go in and they sign a log. Right? They're signing a book. They're signing the register of the city of London. And it made them an inhabitant of the city of London. So all the freemen of said city from time to time being inhabitants. What could that mean? Well, if you take an office, the way that they have their charters written, by taking the office, that makes them an inhabitant of the city. Sort of like being a senator, where they're supposed to have special privileges because they're a senator. Well, there's special privileges because you become a mayor, alderman, whatever, and it makes you an inhabitant, and therefore the only people in the city that are inhabitants are ex officio inhabitants that are the officers of the city. And because now they're inhabitants, well, now they can vote on things that have to do with the city that, you should have a vote on, but you don't because you don't have your title to your property. You're not seen as an inhabitant. And the whole gig is to keep us out of claiming our citizenship within the municipality, which is, it's all about domicile. And I know some people don't want to register anywhere, and I'm the exact opposite. No, I want to register my name, my proper name, Robert Allen Rytlewski, and my property, which is under a name, Robert Allen Rytlewski, with a social security number. That's my property. Put them together. Same place. Here's where I reside. This is my domicile, and this is my property. And what they're doing now is, since they don't give you the jurisdictional address to the place that you're living, for instance, my driver's license has Rockford, Michigan on it, right? 10955 14 Mile Road, Rockford, Michigan. Well, I don't live in Rockford. Rockford's 10 miles away. Right? If anywhere, I live in Oakfield. But, so not knowing, for the last, month, I've been trying to get one of these offices to tell me what it is, and they won't tell you what your address is. It's a secret. And this ties into the legal title and so forth, and as a renter, it's like, well, what am I going to do? Well, then, I found me a form I get to use to take care of this problem. But here you go. I mean, again, a corporate body politic by the name of the mayor, recorder, alderman, and freemen of the city of Grand Rapids. That is the name of the corporation, of the municipal corporation. And, I don't have access to all the records and stuff, but this would be, okay, we can start, this is 1850, and start stepping through. And they had better have the paperwork to back up any change they made, because this is the original charter. And to change a charter takes a referendum, and that referendum would have to have been done properly as an election. And if they didn't do it right, well, then it's election fraud. But enough on those. I just wanted to point them out because to me it blows me away, right? That those are the names of these municipal corporations. So, Assessor. Let's look at something here. It has to do with legal descriptions and assessors. So, legal descriptions, as the name implies, are the way and means by which real property or real estate, they're making a distinction between real property and real estate, and while I'm not really sure exactly what it is, I know it's different, is legally identified, conveyed, assessed, and taxed. When real estate is transacted, it is the legal description that uniquely describes and identifies the property involved in the transaction and all of its appurtenances. So everything that goes with the land, right, is considered real estate. It is not sufficient to rely merely on the address or property identification number, right? So you can't use the property identification number, which we're going to see that they use, right? Like these would be property identification numbers, I guess. Can't go with that. You got to have, for this purpose, your property ownership is legally identified by the legal description on your deed. And they're not letting us see the deed. We get a warranty deed that has a partial description on it. But, that's my opinion, because I know we haven't seen the deed, right? That's being held, that would be the title. We're talking the title deed, right? The title company probably has it. And they go do this abstract of title, and they do all this other bullshit they talk about doing. Well, they're doing that so you don't get to look at it. So it's important to make a distinction early that although tax and legal descriptions may be one in the same, an assessor deals with tax descriptions. So what that means to me is the tax description could read all the same as the legal description. It just doesn't go quite far enough. And I'm going to show you that in a second here. So we leave the legals to the title companies and real estate agents. Well, there you go. Who's got the legal title, legal description? The title company. You want to know what the legal description is on your deed. And so if you're in a foreclosure, you need to tell the judge, Judge, this title, this is not the legal description to my land. I demand you get the title and compare it. Right? Or you're violating my civil rights, or start going down that road. But bring it up to them that this is not the legal description to your land. But better yet, contact the title company and say, I want the damn legal description on the title. It should come as no surprise then, the legal descriptions are also used to identify real property on assessment and tax rolls. Right, some kind of legal description. Right, you will find the use of legal descriptions with an S. So there can be many legal descriptions. The one we want that has to do with the land is the legal description that's on the deed. And the rest of them don't matter. Well, they might, but they don't matter if you're in a foreclosure or if you're paying taxes or whatever. This is my property. This is what you can tax. I don't know what that other number is. I don't know what you're talking about. We're gonna have to get your records fixed. Because legal descriptions are integral to the assessment and taxation of real property, now we're talking real property, it is important for assessing officers to be able to identify and locate parcels by their legal description. To do this effectively, an adequate understanding of legal descriptions is necessary. Well, I would say that is probably true for everybody, having now looked at it. And blah, 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 blah. I don't have time to go through all this. That's what I'm saying. I'm not spending a lot of time on any one thing. I'm trying to kind of rush for time. Types of legal descriptions. The term legal description in this chapter refers to the legal tax roll description, which may be different, knock, 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 may be different from the legal description that will stand up in court for the purposes of identifying and locating a parcel of land. For that purpose, a legal description must conform to the often cited rule which says, if the description in a deed is such that a surveyor, by applying the rules of surveying, can locate the same, such description is sufficient and the deed will be sustained, otherwise it will be void. The surveyor has to be able to find the damn land by the survey or by the legal description. The tax law standard for a legal tax roll description, which isn't the same as the legal description for your land, is found in Section 55 of the General Property Tax Act, which says the county treasurer at any time may reject any tax upon land which has been twice assessed. Land twice assessed. Two different legal descriptions. Right? And say, well, you've already assessed me on this one, and I'm not claiming the other one. Or upon any parcel which is so erroneously or defectively described upon tax roll that it cannot be correctly and easily ascertained, meaning that the legal tax description must be constructed in such a way that can correctly and easily be ascertained by tax officials. An assessing officer must ascertain that all land subject to taxation within their jurisdiction is identified and taxed on the tax roll. Oh, he makes a thing called the assessor's roll. Where is it? See if you're on it. Because that's for the land. The assessing officer must ascertain that all land, right, that would be real estate, not real property, subject to taxation within their jurisdiction is identified and taxed on a tax roll. He or she must also verify that no property is being assessed twice. Well, I'm afraid that's what's happening. And to show you an example, let's go. Okay, so this is doing a parcel search. And actually, this is for the parcel where I live. And so if you looked at the parcel identification, it's got a parcel number, right? That isn't necessarily the number we're looking for, but that's what they use. This is the problem. But look at here. Acreage and lot dimension, 0.00. So this parcel number doesn't have any land attached to it. Well, then it's not an assessment on the land. If we go to the tax description, I believe that's the proper one. Oh, come on, man. What's going on here? Well, never mind. I think I had to have it down here. Anyways, here's the same thing. Here's the tax description. All right, this is a survey. And at the very end, it says 12.37A, which would be for the acreage. And so I think that that's the thing that you need to make sure of, is that they're using the description that actually tells you how much land is involved. And don't let them get away with this crap of saying it's 0.00. Now, Roe had pointed this out to hers, because she has a regular lot. It's like 2/10 of an acre. And they said, "Oh, we just round everything down to the whole number, so it went to 0." All right, this was something they told her a couple 3 years ago, and okay, keep track of that. Don't know what that means yet, but here we are today saying, well, that isn't right. Right? That doesn't tell you how much land it is. It's what it's showing is it's a parcel number identifying something other than land, real property, not real estate. Okay, let's see here. Where was I going next with this? So, I'm done with that. Okay, what I'm going to do is shut this off just for a second. I'll be right back. Okay, so Ro had this as one of the documents that was in her closing papers or whatever the stuff is I hand to you after the closing, right? And here just a couple years ago, she went and tried to record it, because when you read on the website for the county recorder, it says that you can record plat of survey. And so this plat of survey, as you can see, it gives a legal description. Plat of survey of lot 162, unit number 6, Cambridge East, St. Charles, Kane County, Illinois, in the city of St. Charles, Kane County, Illinois, address 1903 Rita Avenue, St. Charles, Illinois. Okay, well, because it was lot 162 of unit number 6, Cambridge East, whatever, I don't know that was enough information for the surveyor to know, but I know that when the surveyor went to survey, he found iron pipe, and he found iron pipe, right? And that set the outside edges, and he found iron pipe, and he found an iron pipe, right? So he found the 4 corners of this piece of property, and so he was able to make a box, right? And so basically, if you can't make a box based on what you're using for a description, then it's not a good description. It can't be open on one end. These are supposed to be closed as boxes. Now, as you can see on here, it also lists that there's a 6-foot public easement and a 10-foot public easement. And it shows a fence line. That's what the X's are, and the black line is the the boundary line, basically, because this is a boundary survey, for lack of a better term. That's what they call them in Michigan, a boundary survey. And if you look at how this line is, where did it do it really bad? right? If this is an easement and there's a fence on the easement, then that would be encroachment on somebody's easement. And if you gave the public an easement, then there you have control of the property and they can do whatever they want. Now, they may have abandoned this easement, right? But we never go to find the document that says what the easement is. My point in all this is, well, apparently the surveyor can find it because he knows there's a 6-foot and a 10-foot easement. And so, when they did this, this was done back when Roe was buying the property, and she said that this Robert A. McNees and Associates was the attorney for the seller, and certified under hand and seal, blue ink signature, State of Illinois professional land surveyor, certifying that he did it within this professional service conforms to the current Illinois minimum standard for a boundary survey. Right? He did as little as he could, because they can do more, right? They have the access to the information, so you can see that the boundary line doesn't follow the fence line exactly, and I think that's on purpose. And then they got a frame shed that's sitting in the public utility easement, and they could say, well, that's a reason for us to tax you because you got your stuff on our easement. It doesn't matter, you gave it to them, and that you could go and get rid of it. You haven't, so they have an easement. They got 10 foot in the front yard. That's that style. And then in Michigan we have something a little bit different, where this was really nice that the surveyor was pointing out the differences between a mortgage inspection and a boundary survey. And it starts right at the beginning with the legal description. I gotta close some of these. You gotta go. You gotta go. Okay. So here's some of the differences, right? The legal description, this is on a mortgage inspection. Legal description of property from tax description. And you can read what it says, blah, 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 blah. And how is that different? It isn't much different. It's got the same blah, 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 but this legal description came from the title insurance company, and it includes as recorded in instrument number whatever. So it's this legal description as recorded in this other instrument. This other instrument, this 2000 with all them zeros, is going to have the proper legal description. Now you look at this one. So again, this is a boundary survey. So on the boundary survey, they got the, found the corners, symbol showing iron set, illustration of pool, encroachment into easement, a 30-foot private easement for public drainage. It didn't say a 30-foot public easement for public drainage. No, it said a private easement. This is why the most powerful man in the county is the drainage commissioner, because these are all in his name. And because that pool is sitting in that easement and it's a private easement, I'm sure they put a lien against that property for putting the pool on their easement. Although it's a private easement, and if we went and looked at the records, it would tell us how to get rid of it, what needs to be done, right? Because somebody can't make you a party to their private easement from before. Now that doesn't show up on here, right? It just shows the pool. It doesn't show any easements, property lines, no illustration of fence encroachment. Right, on this other one, there must have been some fence encroachment. Well, there you are. Illustration of fence encroachment. All right, you encroach on somebody's easement, they can sue you. Okay, and then the key is, well, I'm not going to say it's key, but here's the thing. This is a certification for a boundary survey. I certify that the buildings improvements are located entirely thereon, and the said buildings and improvements are within the property lines, and that there is no existing encroachments upon the lands and property described unless otherwise shown hereon. Okay, well there you go. He's saying all encroachments are shown on here that go to that piece of property. Now the one thing I didn't see yet is what is the. I think it should. And they may not do that. Maybe they're doing this or not doing it on purpose. But where is the lot size as far as the square footage of the property? But again, right? That may be what's in this legal description. That's location of recordation for plat, right? As recorded in instrument, whatever. And he's saying it's a plat. You got to go find the recordation of the plat. And this one's got a whole bunch more blah blah to cover his ass. Certification of building location, not a survey. We hereby certify that we have examined the premise herein, described that the buildings are located entirely thereon as shown, and that they do not encroach except as shown thereon. Right? But it's not showing thereon that this is the one that doesn't show that, hey, you got an easement across the back of your yard for private drainage. This does not represent a property line survey. No property corners were set and is not to be used for establishment of any fence, building, or other improvements. Lines, the location of fences, walls, and other indications of occupancy along or near the boundary lines are not shown. This report was made from legal description shown above. The description should be compared with the abstract of title or title policy for accuracy. Okay. Abstract of title or title policy for accuracy. That's where we can find easements and exceptions, right? Where we can find all this stuff. I'm guessing. I'm just saying that it ain't on this. We have to go look at more paper. Okay, that's enough on those two. That's with that. I'm going to kind of be clicking through things here, so pause. Okay, there's really no rhyme or reason to how I'm putting this video together. I'm just trying to get a bunch of basic facts done and out of my head so that I can go back and concentrate on one thing or another. But this really came a lot at one time from different sources, and it's like, okay, it's coming out the ears. It's time to do a video. But these are important things. So like an assessment roll in taxation. You want the assessment roll, the list or roll of taxable persons and property completed, verified, deposited by the assessors, not as it appears after review and equalization. So not as it appears here, because this is from the equalization office. Right? So the assessment roll is done by the assessor local, who sends it to the county, to the review board, and they do their thing and play with it, and they give it to equalization, and they equalize the taxes across the jurisdiction, which really means we're going to take somebody else's tax that has a lot of tax and give some of it to you. We'll equalize it. You can help pay his tax, whoever him is. But here's a few things that came out of the general property tax. This is for Michigan, right? So 211 is the MCL 211. Anything in that has to do with general property tax. So what do we have? The State Tax Commission, upon presentation by representatives of the County Tax or Equalization Department, township, cities, of satisfactory evidence of education experience by passage test conducted by Commission, shall certify successful applicant as qualified personal property examiner. Well, it ends up that this qualified personal property examiner is who I would call the assessor down at the township. A certified personal property examiner may examine only the property or the cost records relating to such property of any corporation, firm, or individual liable to assessments within their county, township, city for property taxes under this act. So I'm going to go to the assessor and say, check my property out. Tell me what my tax is, because they've never done it, and we'll see that they were supposed to have. I don't believe I'm on the assessor's list. When any corporation, firm, individual is subject to personal property assessment more than 3 counties in the state, then the corporation, firm, or individual may request an examination be made at their expense by representatives of the State Tax Commission at a rate of 1/10 of 1 mil of the gross value of the personal property of said corporation, firm, or individual. That's right in line with the Cesta KV Act, where you're supposed to go and have an inquest of office to determine the rights, title, and interest in your property. And that's what this would do. For 1/10 of 1 mil of the gross value of all your property, they'll go tell you how much you're worth. Deal. I'm taking that. A designee of a local taxing collecting unit who is certified assessor may examine the books and records of person who files the statement required by Section 19 to determine the property included in the statement required by Section 19 is qualified personal property. Anyways, right, they can look at these forms for you. And so this is the affidavit that we were supposed to be given to the local taxing unit, but it's never happened. More on that in a second. But this is the biggie, right? Statement as to assessable property. A supervisor or other assessing officer, as soon as possible after entering upon the duties of his or her office, or as required under the provisions of any charter that makes special provisions for assessment of property. So if you live in a city that has a charter, you want to see what it talks about assessment of property, and that's for you. I don't live in a city, so I'm using the general law. Shall ascertain the taxable property in his or her assessing district, the person to whom it should be assessed, and the person's residence. It's their duty to know everybody in their district, where they live and what property is theirs, and if it's being taxed. That's what the assessor's supposed to do. Right? So you should be getting something from the assessor, not necessarily just from the tax man, from the assessor. Except as otherwise provided in these sections, the supervisor or other assessing officer shall require any person of whom he believes has personal property in their possession to make a statement of all personal property that the person, whether owned by that person or held for use by another, to be completed. A notice the supervisor or other assessing officer provides regarding that statement shall do all the following. Well, they just told you they're supposed to send you a notice about this statement upon which all your taxable property is supposed to be on. And I'm going to take a look at that here. I think I can find it. Way too many things open. Where's the damn format? Okay, it's just much easier if I turn you off a minute. Sorry. Back. Okay, so new personal property exemption 2014. You may qualify. Blah, blah, blah. All this stuff comes from the Department of Treasury. Actually, the State Tax Commission, right? So that's like the Court of Exchequer. And assessor's responsibilities. Lots of them. But assessor and or supervisor are still required to annually send a personal property statement to any person they believe has personal property in their possession in their local unit. The personal property statement has been revised to meet the notice requirements in the Act. Personal property statements must be sent or delivered no later than January 10th. They got 3 more days to send me mine. I ain't seen it yet. I can show you what it looks like. It should look like this. It's L4175 form. Right, so it's from, this is the name and address of the assessor, and to, this is to me, And then they're going to send me this form that I'm supposed to fill out. Well, I've never seen this form before. No one's ever sent me one of these. Every place is going to have something similar, and, I don't think you've seen it. So where is mine? How come I don't have one? And I had questioned this before, but when I did it like on a FOIA to the township. And they gave me some, snarky-ass answer of some kind. But I didn't go to the assessor who's responsible for it. Because, again, these are all Department of Treasury forms. This has got nothing to do at all with the township as far as a local government unit. This is state business. Now, there's another thing they're supposed to do. Because I don't know how I'm going to work all these out, but I want to make sure I showed them. Along with your warranty deed, when you transfer the property, or for me, because I'm renting this property, we're supposed to do a property transfer affidavit with the assessor. This form must be filed whenever real estate or some types of personal property are transferred, even if you're not recording a deed. It's like, okay, well, you tell me I should bring this and the deed to the assessor? I think that's correct. The assessor needs to have the information. But anyways, still have to do it, even if it was just this form. It is used by the assessor to ensure property is assessed properly and receives the correct taxable value. It must be filed by a new owner with the assessor for the city, township, or where property is located within 45 days of the transfer. It is not filed timely. A penalty of $5 a day, maximum $200, applies. The information in this form is not confidential. Okay. So it's real straightforward. Street address, county, city, township, village. I'm liking it so far. Township, yep. Data transfer, I've been here since 2004. That's good enough for me. Purchase price, I'm not buying it, so I'm not worried about it. I'm going to attach the legal description because I don't know what the PIN is, but I got the legal description that showed the 12.38 acres. I'm going to see how that one works. Who the seller or the transferor is, because I'm not buying it. I was just transferred the beneficial use of the property. I'm renting it. I'm the transferee. And my mailing address. So this form will tie me and my mailing address to the physical location within the township, attached to a legal description which has the land on it, which is the de jure jurisdiction, and I should be back into the Republic. And in the instructions, it says this form must be filed when there is a transfer of real property or one of the following types of personal property. Buildings on leased land. Well, I could say that's what I did, right? I'm renting a building on leased land and leasing the land. Leasehold improvements, leasehold estates. And it lists all these other ones: deeds, land contracts, yada yada yada. These are conveyance of title or present interest in property, including the beneficial use of the property. I'm using the property, so I have to do one of these. I'm not exactly sure how I have to do it, but, what the heck. If I made a mistake, well, please forgive me. Let's do it the right way. Type of transfer. I did a lease. Right? So this form, if I had bought the property, I would take this form also, and it would be, that I bought the property. And this is, going to be the transfer affidavit. This shows that you're transferring the title to the property in one form or another, either the legal or the equitable or both. Okay. Hey, I apologize if I'm talking really fast and kind of jumping around, but that's really what kind of video this is, and I need to get this done. I'm hungry. I gotta make some dinner. But I do want to point out this is now we're getting into the meat and potatoes, right? Real estate transfer tax law. So this is in Illinois, under the property tax code, section 31, which 31.1 is the real estate transfer tax law, at least the name of it. And what it says is imposition of a tax. Tax is imposed on the privilege of transferring title to real estate located in Illinois. Okay. Or fraction 500 stated in the declaration required by section 3125. So apparently there's some kind of declaration that you have to have with this. Paper revenue stamps the tax shall be collected by the recorder or register of titles of the county in which the property is situated through the sale of revenue stamps, the design denomination form of which shall be prescribed by the department. What about electronic? And they could also have electronics, almost like a mailing sticker. Well, heck, I'll show you one. Right? Like this. So these are what we're talking about. And these are on your warranty deed. The problem is they're not canceled. These aren't properly canceled. That's where I'm headed with this. Let me look right now. Where was I at? There. The department may prescribe a form to which stamps must be affixed that a transferee must file for recordation at time a declaration is presented if the transferring document is not presented for recordation within 3 business days after the transfer is effected. Yada, yada, yada. What's all that mean? I don't really know. But what I do know is a person using or affixing a revenue stamp shall cancel it, and so deface it as to render it unfit for reuse by marking it with his or her initials and the day, month, year when the affixing occurred. See? Shall. They shall use their initials, the day, month, and year. Well, here is a true and correct copy of a warranty deed for a guy that's being foreclosed on right now, and those haven't been canceled. Well, that means his property hasn't been recorded. Right? Then this is the thing. He's not the recorded owner of the land. The marking shall be made by writing or stamping in indelible ink or by perforation with a machine or punch. Okay. Transfer declaration. At the time a deed, a document transferring a controlling interest in real property, or a trust document is presented for recordation, or within 3 business days after the transfer is effected, whichever is earlier, there shall also be presented to the recorder or register of titles a declaration signed by at least one of the sellers and also signed by at least one of the buyers, in which the transaction or the attorneys, the agents for the seller or buyers. So the sellers, this had to be done prior to you finishing the deal, because the seller and the buyer both have to sign this form, or it can be signed by their agents. Oh, I wonder if that's what they did. The declaration shall state information, including but not limited to. It gives a whole list of information, right? This document that they're talking about, this declaration, isn't this. Because you don't put the revenue stamps on the declaration. It isn't going to be recorded. It just needs to be with it. Except as provided in the 3145, a deed or document transferring a controlling interest in real property or trust document shall not be accepted for recordation unless it is accompanied by a declaration containing all the information requested in this declaration. When the declaration is signed by an attorney or agent on behalf of the sellers or buyers who have the power of direction to deal with the title to the real estate under a land trust agreement, the trustee being the mere repository of the legal record or the legal title with the duty of conveying the real estate, only when and if directed in writing by the beneficiary or beneficiaries having the power of direction. In other words, you got to tell the title company to transfer the title. Apparently. Right? Under a land trust agreement. Well, we could go into what that means exactly, but I'm just going to say this, that you don't have the legal title, so somebody else does, so it's being held in trust. Right? The title to the land is being held in trust, the title deed. The attorneys or agents executing the declaration on behalf of the sellers or buyers need identify only the land trust, that is, the repository for the record, legal title, and not the beneficiary or beneficiaries having the power of direction under the land trust agreement. The declaration form shall be prescribed by the department and shall contain sales information questions. And I don't remember if I found one for them or not. Oh, that's the tax. No. Assessors due, tax exempt, Michigan, Prairie Sen, Illinois assessor duty, certified rural, personal property, personal. I don't think that, shoot. I don't think I have it. Well, it'll be in the next video. But the point is, that this says that these damn revenue stamps have to be canceled. And here's a warranty deed. See, it's got a title company here. That's why I think the title company is who we're going to call the trustee. Right? This has got the stamps on them, but they haven't been properly canceled. So this hasn't been recorded. Can't be recorded until those are canceled. And it didn't happen. Well, let's see what Michigan says about that. Real estate transfer. Okay, a written instrument subject to the tax imposed by this act shall state on its face the total value of the real property, or there shall be attached to the instrument an affidavit declaring the total value of the real property. The form of the affidavit shall be prescribed by the State Tax Commission. And I think that that's what I was showing you earlier. If everything hadn't kind of gone bonkers on me here. Oh, I need a piece of shit. Oh, right, here's the one for Michigan. Property transfer affidavit. Yeah, purchase price of real estate, right? So you could put the real estate price on there, and that's what it asked for. Declaring the total value of the real property. Okay. Exemptions, document stamp purchase, methods of affixation, cancellation. So again, this is Michigan. This is the real estate transfer tax. It has its own act. It's 134 1966. So you may have something similar where it's part of your larger act for property, or it's a separate standalone act like it is here in Michigan. But real estate transfer is what we're talking about. Right? Name of your state, real estate transfer, tax, Google it, and start reading. And you will find that the tax imposed by this act shall be evidenced by affixing of a documentary stamp or stamps to every instrument subject to the tax imposed by this act by the person making, executing, issuing, or delivering such documents. Okay? Every instrument subject to the tax imposed by this act by the person making, executing, issuing, or delivering such document. The documentary stamps shall be purchased only in the county for which the property is located. The stamps shall be affixed in such manner that their removal will require a continued application of steam or water, and the person using or affixing the stamps shall write or stamp thereon his initials and the date upon which the stamp was affixed or used, so that the stamp may not again be used. Now, in Michigan, we do it even, we got something going on here because they talk about putting them on the back. The treasurer may prescribe such other method of cancellation as he deems expedient. Now, that's the state treasurer. So if you go to the county, they say, well, we don't do it that way, we do it this way. You say, well, show me where the state treasurer said that you can. The treasurer shall, if required by state treasurer, utilize the tax meter machine, which shall be provided by the county. And, right, that was a meter machine. Right, that's what that came from. So if these aren't canceled, right, then the state isn't getting their revenue, and that makes it tax fraud. And you bring that to the attention of the assessor. Hey, how come these aren't canceled? Isn't this tax fraud? Well, now they're a witness or a defendant. And, that may be the quickest way to get to the bottom of it. But it went on here to say, recording requirements, detachment of affidavit, use. No written instrument subject to this act shall be recorded in the office of any register of deeds of any county of this state unless documentary stamps as required by this act have been purchased at the time of presentation by the party responsible for their purchase according to subsection 2 of section 2. Well, let's go look and see who that was. Who's responsible? Subsection 2 of section 2. The tax shall be upon the person who is the seller or grantor. They needed to do it. The stamp shall be affixed to the face of the instrument prior to recording unless the person specifically requests that the instrument be recorded prior to affixing the stamps. In the later case, the stamps may be affixed to the reverse side of the instrument. However, in those cases where it is necessary to record said reverse side, the stamp shall be affixed after recording by the Register of Deeds. Now, I don't know what that means, but it's like, okay, well, yeah, if they put the stamps on the back side, you're going to have to tell them to record the back side of the paper also. And this is the thing about getting true and correct copies to see what it is you have. But, you could just ask point blank, does that warranty deed that you have any revenue stamps attached to it? And tell them to record the back. The stamps may be affixed to the reverse side of the instrument. However, in those cases where it is necessary to record said reverse side, the stamp shall be affixed after recording by the Register of Deeds. Okay, but the transfer can't be completed until the revenue stamps are on it and canceled. So again, where's the stamps and are they canceled? If they're not canceled, your document has yet to be recorded, which means you're not the owner as far as the record's concerned. An affidavit attached to a written instrument under provision of this act shall not be recorded and shall be detached from the written instrument. So you had to bring it there, but it doesn't get recorded. Prior to the recording of the instrument, such affidavit shall be used for county fund auditing purposes only and shall not be disclosed to any other persons. So, there you go, right? You want to look for these on your document. You don't need to be, right, for this kind of stuff, you don't need to be in foreclosure. You need to go do this now so you can own your property. Okay, I had one more thing, I think, so give me just a second. Okay, this is the oath of a town assessor for David R. Medlin. Do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of Illinois, as I will faithfully discharge the duties of the office of Deputy Assessor to the best of my ability, and I will, without fear or favor, appraise all the property in said town. Town would be a survey township, I believe, not the civil township, the survey township, because that's where the land is. At its fair market cash value, said value to be ascertained at what the property would bring at a voluntary sale in due course of business and trade, and I will assess said property when so appraised at full cash value. So another one, right? So it's got fair cash value and full cash value, two different values. Then I will cause now this is the important part, that I will cause every person, company, or corporation assessed to sign his, her, or its assessment schedule, and I will administer to each and every person so signing said assessment schedule the oath thereon, and return said schedule so signed and file the same as required by law. Well, Rosita has never had anybody come up to her and ask her to sign this piece of paper and swear an oath. Where's the assessment schedule? They took an oath to give it to you. That's treason, brother. You took an oath. You're violating your oath. So there's something about these assessment rolls. This is what it says in Michigan. On or before the first Monday of March, each year, the assessor shall make and complete an assessment roll, upon which he shall set down all the following: the name and address of every person liable to be taxed in the local taxing collecting unit, with full description of all real property liable to be taxed. Please put me in the frickin' roll. If the name of the owner or occupant of any tract or parcel of real property is known, the assessor shall enter the name and address of the owner or occupant opposite the description of the property. Well, that's what would happen if you put that property transfer affidavit in. They would have the information. If unknown, the real property described upon the roll shall be assessed as owner unknown. That's all of it is right now. The land is all unknown. Nobody knows who owns it. Each description shall show, as near as possible, the number of acres contained in it. Now we're talking land again. A defined piece of the face of the earth as determined by the assessor. It is not necessary for the assessment roll to specify the quantity of land comprised in any town, city, or village lot. So if there's no land involved, you're not the owner. The town, the city, or the village is. Right? It's not an individual's lot. So, duh. The assessor shall estimate, according to his or best information and judgment, the true cash value and assessed value, two different values, for every parcel of real property, and set the assessed values down opposite the parcel. Where is the assessment roll? See, this is that roll they talked about before it goes to the Board of Review and to equalization. The assessor shall determine the percentage of the value of every parcel of real property that is exempt from taxes levied by the local school district. The assessor shall determine the date of the last transfer of ownership of every parcel of real property occurring after December 31st, 1994, and set the date down opposite the parcel. That's where you would know if you're being seen as the owner. Do they have the last date down? The assessor shall estimate the true cash value. Now we got true cash value of personal property. All right, that was real property before. Now it's all personal property of each person, and set the assessed value and tentative tax value down opposite the name of the person. So you really want to be on this list. This would put you in the jurisdiction. They couldn't say that you don't exist anymore. Now Now, tax rolls. Notwithstanding any provision of this act, the county, by resolution of the Board of Supervisors, may prepare tax rolls and extend the taxes thereon for cities and townships in the county at the expense of the county or local unit. Well, that's not the assessment roll. This is the tax roll. I don't want the tax roll. I want the assessment roll. And I want the real estate index numbering system. May establish a system for listing real estate, right? Not real property, not personal property, real estate for purposes of assessment and collection of taxes, but not to determine the tax. The assessment and collection, but not the determination of the tax. That's what equalization does. We want the one for the assessment. In addition to or lieu of a method of listing the legal description provided in this act. The system shall describe real estate by county, township, section, block, parcel, or lot. The numbering system shall be approved by the State Tax Commission. The assessing officer shall establish and maintain cross indexes of numbers assigned under this system with the complete legal description of the real estate for which said numbers relate. So if you want to use a number, fine. Show me the legal description that goes to the number of the real estate. Not real property, not personal property. I want you to show me the one that they're talking about in the tax law 25A. And you show it to the assessment. If they don't do it, well then, then you take it to the treasurer of the state for tax fraud. The assessing officer shall assign individual index numbers and the assessment rolls, tax rolls, and tax statements shall carry the index numbers and not the legal descriptions. But the problem is, what's the real number? Because they have a number with no dashes, and sometimes they have it with dashes. And then they have special assessment rolls. Right? So we're going to have a conversation with our assessor. And that's, what I guess what I was showing is I'm going to go fill this form out and take it down to her and see what she has to say. And there's one other thing. This is a little blurb that the State Tax Commission sent in October of 2014. Asked that all assessing officers review their personal property accounts and ensure that each physical location has a separate personal property account number, rather than a single personal property account number for multiple physical locations. And, in my head, what that means is, well, before, they just had one number, and it was tied to the township hall, and it was, one number for everybody. But now, they have to actually have an account number for each physical location. And all this went into effect this year, in December of 2015, and by the 10th of this month, I'm supposed to have gotten this statement that I've never gotten before, and I'm not really waiting for that to happen. I'm just saying, there's things that have changed, and I think it has to do with Pope Francis and his motu proprio back in 2013, where he was removing these people's limited liability. And because assessor, hey, that's an ecclesiastic term. Okay, well, I hope you got something out of this. I covered the things I wanted to cover, and I'm going to go back and now pick one or two things and do something with it and do a video on it. But if you're in a foreclosure, or even if you're not, right, you need to understand what the assessor's doing and find out why you're not on the assessment roll, and make them put you on the assessment roll in the house that you live in, and you will no longer be homeless, and your property won't be vacant, and they won't be charging you for taxes on a description that doesn't have any acreage to it. And that will remove the fiction from your life, because then they can't double tax you, right? Right now you're being taxed in the fiction because you're not in the other one. You get in the one with the real estate, well, then you won't be taxing the fiction anymore. They couldn't do it. It would be double taxation, and that's the assessor's job to make sure you're not double taxed. It'd be an interesting couple of weeks coming up. All right. You all have a great night, and I'm sure we'll be talking again soon. See ya.